Hello friends, welcome once again. You're connected to the Supreme Court Historian YouTube channel, and in this video we will be looking at our first ever criminal case, the first ever criminal case for our channel, decided by the Supreme Court on the 1st of June 1951, Tara Singh versus the state, a landmark judgment for various reasons which we will of course make clear as we go along. As usual, we shall begin with the facts of the case, which are as follows. 30th September 1949, the accused Tara Singh attacked and killed with a kirpan, which is basically the traditional dagger that the Sikh individual is expected and required to carry on his person at all times. With his kirpan, Tara Singh attacked his father Hakam Singh and his uncle, his father's brother, Milkha Singh. So this was a parricide as well as an avunculicide. Milkha Singh was killed on the spot. Hakam Singh survived for a week before perishing finally of his injuries on the 7th of October. There were witnesses as well, the rest of the family basically, who ran in when they heard the cries of the victims. So the accused's brother Narinder Singh, who was the one who went to the police with the information and filed the FIR, the accused's brother Jito, and the accused's mother, the now widowed Shanti. So they, when they entered wherever this altercation took place, they found that Milkha had already died lying on the floor, while Hakam was still being attacked by his son Tara Singh. Later on, the prosecution tells us that Hakam Singh, before dying, informed on 3 separate occasions the police as well as the magistrate. Twice the police, once the magistrate. 3 different occasions he gave these dying declarations, informing them who had carried out the attack on him, on his person, and he pointed to his son Tara Singh. So a tragedy of massive proportions, whichever way you look at it. The motive is not relevant for us in our discussion, but you can guess what has happened. It was driven by a property dispute. Basically, Milkha Singh, who was issueless, declared that he was going to donate his property to the Gurdwara, and his nephew obviously had other ideas, or had ideas for that property. That led to the dispute, and that is why Tara Singh killed his uncle Milkha Singh, and Hakam Singh must have come to his brother's defense or tried to talk some sense into his son, and died in the effort as well. It was also claimed by the prosecution that Tara Singh confessed to committing these 2 heinous offences to 3 individuals from the village. Their names are noted in the judgment, and these names are relevant later on, believe it or not. Ujagar Singh, Fauja Singh, and Gurbaksh Singh were the recipients of Tara Singh's confession, if the prosecution is to be believed. What happened next? Well, Tara Singh was tried and convicted by the Amritsar Sessions judge. They found him guilty of the double murder and sentenced him to death. The death sentence, as per the Criminal Procedure Code, requires to be confirmed by the High Court, and the High Court of Punjab did confirm the death sentence for Tara Singh. The Punjab High Court at that time, 1950s we are still talking about, was actually seated at Shimla, in fact at the very famous Peterhof building in Shimla, which used to be the residence of the viceroys. And later on, as a further historical tidbit, for those of us who are interested in such things, it is the same building where Nathuram Godse was also tried for the assassination of Mahatma Gandhi. Anyway, coming back to our case, where Tara Singh was found guilty and convicted of murder and sentenced to death sentence confirmed by the High Court of Punjab. And Tara Singh then, in response, approached the Supreme Court under Article 136. This is our first encounter with Article 136, which allows us to put before the Supreme Court what we call Special Leave Petitions, SLPs. are something that we will encounter time and again in our journey through the history of the Supreme Court for its 7.5 decades. The title of the article is Special Leave to Appeal by the Supreme Court. Let's just recall what the word leave literally means. We tend to misconstrue it and confuse it with making it a synonym of going absent or something like that. That is not what leave actually means. Leave literally means permission. So a special permission by the Supreme Court to appeal before it. The Supreme Court may in its discretion grant special leave to appeal from any judgment, decree, determination, sentence or order in any case or matter passed or made by any court or tribunal in the territory of India. There's a few words at the start of these which I have not pasted here, notwithstanding anything else in this chapter. Basically, the articles 132 to 135 talk about appeals to the Supreme Court, the appellate jurisdiction of the Supreme Court in case of constitutional law cases, criminal law cases or civil law cases. In any of these cases, if the High Court has made a judgment and one of the parties wants to appeal that judgment, then the High Court can provide a certificate for appeal if the High Court believes that constitutional interpretation or something similar needs to be looked at by the Supreme Court through this particular case. If the High Court refuses to give you a certificate, that does not end your chances for appeal. If you can convince the Supreme Court that your case is worthy of its time, then you can apply for an appeal, for an appellate hearing under this article, Article 136. It's a very short argument that the court hears, so it takes a very skillful advocate to put your case before the Supreme Court under Article 136. And once you convince the court to hear your matter, then of course it proceeds like any other hearing. But that crucial threshold has to be met, that the Supreme Court believes that special permission should be granted to you for this particular situation. And in this situation that we have at our hands, the court definitely found sufficient reason to look into it. And indeed, they ordered, or rather they accepted the appeal, and they sent the case, the trial, back to the lower courts. It was a 4-0 verdict, with Justice Vivian Bose writing the judgment for himself and for his brother judges, Sayyid Fazal Ali Patanjali Shastri and Sudhir Ranjan Das. All four agreed that something really strange has taken place. So we will take a look at that, but a moment to mention once again that the judgment was written by Justice Vivian Bose, who basically effectively headed this bench. He was a late entrant to our Supreme Court. For those of you who have been tracking all our videos will recall that he was not there in the A.K. Gopalan case, for example. He was added quite clearly because of his expertise in the criminal matters. Now, before we proceed into what was presented before the court and what the court found in its hearings, let's take a moment to remind ourselves or to inform ourselves what the procedure is in criminal matters. I'm not talking about the court procedure necessarily, but everything. What happens once an offense has taken place, once somebody has committed an offense, what happens next? The first step is somebody goes to the police, files a complaint or a first information report. That is the trigger for the police, for the local police, to carry out an investigation to figure out who it is that has committed that particular offense. They look at various suspects, they collect evidence, and they come to the conclusion that this particular person has committed that particular offense, in this case Tara Singh. Then they go ahead and arrest that person, and within 24 hours he needs to be presented before the magistrate. Once produced before the magistrate will look at whatever arguments the police have to make regarding whether they have gathered all available evidence or there is still some evidence to be gathered which could be tampered with, and accordingly the magistrate will decide on either granting bail to the accused or remanding him to judicial custody, or the worst as far as the accused is concerned, remanding him to the custody of the police who have arrested him. Meanwhile, the police continue their investigation and complete their investigation report, and this investigation report along with witnesses is brought before the magistrate, who now has to decide what is to be done. This decision making happens in a committal procedure. It is the word is committal. In case the offense that has taken place carries a sentence of more than 3 years imprisonment, in that case the magistrate will commit that particular trial to the sessions court. The sessions court is equivalent to the district court on the civil side. If on the other hand it carries a sentence of less than 3 years imprisonment or only fine, in that case the magistrate will himself try that particular case or go for even a summary trial, but we are not going to get diverted by all of those. The point is that there is something called a committal proceeding, which is the American equivalent, if many of you must have watched US movies etc., is the preliminary hearing. That is the first time that the evidence is presented before the judge, and the judge then figures out if it is possible that a jury could find the accused guilty. Only then will the process move forward to a trial, or else that person will be discharged. The charges against him will be dropped. In this particular case, the magistrate found sufficient evidence that Tara Singh should be tried for that particular double murder by the sessions judge at Amritsar. The trial was carried out. Tara Singh was convicted and was not acquitted, and we have seen what happens next. So the third and fourth point on this particular slide is where all of the problems took place. There is no question about the police doing anything wrong. They did their jobs and then some, but the magistrate at the committal stage and the judge at the trial stage came for some censure by Justice Vivian Bose of the Supreme Court. They found that there had been several procedural lapses at the committal stage. First of all, the accused did not have legal representation. Now this seems a little difficult to believe, isn't it? But try and recall that the code, especially the old criminal procedure code, which was applicable over here, remember that the CRPC was completely overhauled 1973 onwards, but at this stage, 1950s or even 1949, when this offense took place, the criminal procedure code of 1898 was in force. And anyway, the code required the magistrate to grant the accused sufficient opportunity, afford him the opportunity to seek legal representation. It's not that the magistrate denied him representation, it's that the accused did not look for legal representation. So nothing specifically vitiating in that particular point. The problem is that if the accused did have legal representation at that time, things would have perhaps gone a little differently. So why was there no legal representation? Justice Vivian Bose has noted in his judgment what the possible problems could have been. He states that in this peculiar case, the accused failed to get help from his family members, obviously because the family members were not only witnesses, they were also the victims, because they had lost their the head of the family and his brother as well. So obviously it is understandable that they did not help out Tara Singh. That could be one of the reasons why legal representation was not found. Normally it is family members who contact a lawyer as soon as somebody from the family gets arrested and accused of any offense. Something as grievous as murder will of course result in all of that taking place, but it did not happen in this case at all. Secondly, the court has noted that the accused was not properly examined at the committal stage. This is another requirement of the code, although the actual section uses the word may, that the magistrate may question the accused. The Privy Council has held in that judgment that I have mentioned over there, Dwarkanath versus Emperor, that if a point in the evidence is considered important against the accused and the conviction is intended to be based upon it, then it is right and proper that the accused should be questioned about that matter and be given an opportunity of explaining it if he so desires. What was happening was that all the evidence that we saw in that earlier slide, all the evidence against Tara Singh, there was the dying declarations from his father, from his victim. There were also the witness statements from his other family members, and there were also the extrajudicial confessions, the fact that he had confessed to 3 separate individuals on that same day. All of those were giving this case the nature of what we call an open and shut case, isn't it? It really looked, everything was stacked against him. But that does not mean that he should not be questioned about it at all. He should be given an opportunity to explain all these things. He should be given an opportunity, for example, to explain why these 3 individuals are coming forward and saying that you confessed to them. Right? Are they friendly towards you? Do they have any enmity against you? You know, some old dispute that you have had. Is that the reason? Could that be the reason? Or are they really telling the truth? These kind of questions are asked to the accused at the committal stage to figure out if indeed this matter should go to trial or something else is happening. But no such questions were asked. The questions that were asked to the accused were not in the nature of a chief examination either. They were in the nature of a cross-examination. I have pasted 2 of the examples of the questions that were asked. Question 1. Was Milkha Singh deceased your uncle issueless and wanted to gift away his land to the Gurdwara Baba Bakala, which fact you resented? This should not be one question. This is quite clearly a leading question, the kind of questions we ask to somebody on the stand when we are cross-examining them. This should have been broken up. Was Milkha Singh your uncle? Yes. Was he issueless? Did he not have any children? Yes. Did he want to gift away his land to the Gurdwara? Yes. Did that make you resent him? Yes. That is how this should have progressed. In fact, instead, all of that was put forth in one single question. Did you also resent your father mortgaging his land? Was once again multiple facts coalesced together, concatenated into one single question. This is precisely what should be avoided, and this was done by the magistrate, which was rather unfortunate. And that is not all. Further, the accused was not even informed as to who gave the testimony against him regarding the motive. How is it that the police in their investigation found out that Milkha Singh, the accused's uncle, was going to give away his land, donate it to the Gurdwara? How did the police come across this information? Who gave it to them? Is that person who gave that information to the police a reliable witness? None of that was presented to the accused. He was not allowed to refute that information. He was not informed, he was not questioned about the dying declarations. The questions should have been, we have dying declarations from your father. Dying declarations are the only hearsay evidence that is allowed under the Indian Evidence Act. Basically, the court always looks for direct evidence given before the judge, but that is not obviously possible when the victim has expired. So what happens then? If in case before dying the victim has told a reliable authority who has committed the crime against him, who is it that has caused his death, then that declaration by the victim is admissible in court, provided it is made to a proper authority. In this case, 3 different dying declarations were given by Hakam Singh, who survived for a week after the attack. Before dying, he gave the first declaration to the police, the second as well to a different police officer, and the third dying declaration was, as per procedure, given before a magistrate. So all of this was available against you, Tara Singh. What do you have to say about this? Do you have any reason why your father would testify against you? These kind of questions should have been asked to him. They were not. Thirdly, and this is really incredible, the names of the witnesses before whom the accused supposedly confessed were recorded incorrectly by the committal magistrate. which is why I've mentioned the original names, the actual names, Ujagar Singh and Gurbaksh Singh and Fauja Singh. Those were the three against whom, or rather before whom, Tara Singh had purportedly confessed. What is recorded in the committal judge's report, Ujagar Singh, Mangal Singh, etc. So he's not even recording them properly. Then it is evident that he must not have questioned Tara Singh about these individuals. Were they friendly to you? Were they unfriendly to you? Did they have any dispute with you? Why is it then that they are saying that you confessed to them? None of these questions were asked to the accused. And interestingly, Justice Vivian Bose says that even up to this limit, we could have accepted and gone on with whatever the courts have decided, because this is, after all, just the committal stage. This is only there so far. Whatever has been decided is only there to figure out whether Tara Singh should be tried for that double murder or not. He was tried, and even if there were all of those lapses, at least the worst case was that he was tried. That is all that he had to pay for. But what happened at the trial? Again, over there, the examination of the accused was not in accordance with the provisions of the code. Now, we saw that at the committal stage, there was no legal representation. If there was a lawyer present along with Tara Singh, she or he would have ensured that the court would ask the accused Tara Singh about all of those things that we just discussed, about those dying declarations, about those extrajudicial confessions, about those people to whom who are claiming that he confessed before them. All of those things would have been ensured, but the magistrate made the mistake there of not insisting that there shall be legal representation. But there was legal representation at the trial stage. Of course there was. But nonetheless, even then, the examination of the accused in the trial court was not in accordance with the provisions of the Criminal Procedure Code. The accused was not asked to explain the circumstances appearing in the evidence against him. Once again, the accused was only asked whether statements made before the committing magistrate and the answers given were correctly recorded. Once again, the question was posed just like that earlier question, where 3 or 4 facts were jammed together and one single question was asked. Were the statements made before the committing magistrate recorded, and the answers that you gave were they correctly recorded? Yes or no? These kind of questions tend to confuse people, especially in the rustic accused or rustic witnesses, individuals from rural parts who may not be educated. And even if they are educated, and even if they are urban or whatever, when you are facing a trial for murder, you are bound to be in a very different mental state, and things should be made very clear to you in a very simple manner. Instead, these questions were asked in a very confusing manner. Further, the problem was the witnesses, 3 witnesses, his family members. 2 of them were not even confronted with the statements that they had made at the committal stage. Basically, they were merely asked that, what do you stand by whatever you said to the committal magistrate? And they said that no, we were coerced to give those statements. That is all. Nothing further was pursued. The matter was left there, and all of this led Justice Vivian Bose to conclude that something drastically wrong has happened. And the important parts of the judgment I'm going to just read out from this slide. The whole object of examining the accused during the committal and during the trial is to afford him a fair and proper opportunity of explaining the circumstances which appear against him. There should be an opportunity given to the accused to explain all the evidence that is there against him, all the circumstances that appear in the record against him. How is it that this has happened? And this fairness requires that each material circumstance should be put simply and separately in a way that an illiterate mind, or one which is perturbed or confused, can readily appreciate and understand. Disregard of this provision is so gross in this case, according to Justice Bose, that there is grave likelihood of prejudice, and that tends to be the problem with open and shut cases. Everybody just assumes that it is just going to sail through, and people tend to make mistakes, especially on the prosecutorial side. The common man fails to understand how complex a prosecution is and how much pressure exists on the shoulders of the public prosecutor, especially in open and shut cases, because you're expected to win the trial. But there are quite a few procedural safeguards available which should be resorted to, which should be adhered to, which were not in this particular case. And apart from all of those questioning things, out of the three witnesses were not confronted with previous statements made by them, thus violating Section 145 of the Indian Evidence Act. The Indian Evidence Act, Section 145, allows us to confront the witnesses that are giving testimony with testimony that they had given previously and which has been written down, and then that particular testimony can be used to completely destroy whatever they're saying, completely destroy it during cross-examination. Since in this particular case the accused's mother and sister were not confronted with their previous statements, just Narinder Singh, the brother and complainant, was confronted. The other two were not. The testimony given by those two was inadmissible. This meant that sufficient and significant material on which the conviction relied, on which the conviction was based upon, was considerably weakened, and with this weak material the conviction should not have taken place at all. And Justice Bose then goes on to say that I am quite anxious and concerned about what should I do with this case now. Should I completely acquit Tara Singh? That is not the right approach over here, because there is sufficient evidence, there is quite a lot of evidence actually prima facie that he has committed these offenses. It is just the procedural lapses which force me to do something about what has come before me. So the options before Justice Vivian Bose were either to order the trial to begin from the stage where the lapses occurred, or to order a completely new, fresh trial, and that is what he decided upon. A retrial de novo by the same or another sessions judge. He specifically mentioned that because he said that he did not want to influence what happens in the trial court now, and so he said a retrial de novo by the same judge or by another judge, depends on that court's registrar. And the other three judges agreed with this opinion. So this is the first time that the Supreme Court ordered a retrial, and this became a landmark case which has been referred to in several future criminal trials in the lower courts as well as in appeals in the High Court, etc., where especially this point about Section 145 of the Indian Evidence Act 1872 was under discussion. So that concludes our first criminal foray into the Supreme Court's adjudicatory history, Tara Singh versus the state. See you next time with another landmark judgment. Thanks for listening. Bye-bye.